Thank you for your reminder, Ludmilla. Now then, so we're recording this lesson. Now, this course, I want to do two things with this course. I want to improve your legal vocabulary and your ability to speak and write in English, legal English, and also I want to improve your legal writing skills. Today's lesson is going to be about vocabulary. There are a number of commercial legal topics we're going to look at in this course. We're going to start with company law, company formation. In a couple of lessons' time, we'll move to contract formation, contract law, and then we'll have some lessons on contract drafting in plain English. Right, so I've sent to all of you a link to a textbook, which I think it was Kiev Mahila University. It may have been Taras Shevchenko, I don't know. But completely in breach of all copyright, they uploaded a textbook onto the internet. I think the people who wrote the textbook, the Kreuz-Lindners, are pretty angry with them. But the simple fact is, the Kreuz-Lindners published a new version of the book to overcome the problem caused by Mahila or Shevchenko University uploading the book. So it's available for use. And we're going to use that book this evening. We're going to use it a lot during this course. So what I'm going to do now is I'm going to share my screen. I'm going to switch off the camera. I'm going to bring up the book, and I'm going to go through a text which I asked everybody to have a look at in the last lesson. I'm just going to deal with some of the vocabulary, and then we're going to deal with exercises relating to the vocabulary and the law relating to company law. Company law first, then contract law, then we'll look at the law relating to intellectual property and finance and banking. Okay, so let's increase the size of this, right? I'm going to ask everybody to mute their microphones unless they're going to, unless I actually ask one of you to speak. Right, let's first of all switch off my video. Now let's share my screen. Now let's bring up the ILEC book. Where are we? Excuse me just a moment. Oh, here we are. Right, let's move this out of the way. Excuse me, Anastasia. There we are. Well, this is chapter 2 of the book, Company Law. It's the words and a very general overview of company formation, the law relating to company formation. But one of the things you'll be asked to do if you do join a commercial law company is to be involved with the simple procedure of forming companies. Exactly the same, really, as if you joined a big law company in Ukraine that dealt with that. It's one of the simpler tasks for lawyers to perform. So the first thing I should tell you about company law in the common law countries is this. Company law has been around an incredibly long time. The oldest existing company in Western Europe is the Kuperberg Mining Company from, I think it's Norway or Sweden. It was founded by a royal charter in the year 1074, I think, over 1,000 years ago, by King Magnus VI. Berg is the Icelandic word for mountain. Kuperberg means copper mountain. It's a mining company. It's over 1,000 years old. Companies have been around an incredibly long time. So, as you can probably guess, in the common law countries, the law relating to companies, although it's now governed by statute, is in fact based on the common law principles. Now, 500 years ago, 600 years ago, 400 years ago, when Queen Elizabeth I was giving out monopolies to her favorite lords and dukes and bishops and cardinals, They didn't want the ordinary people, the common people, the general public, to know that they owned companies. So by tradition, it has always been the case all around the world that the list of shareholders who own the shares, who own the company, has always been kept secret. It's a common law tradition, and it's been incorporated into company law around the world over the last 200 years. Right, so basically, a company is a legal person. That is, it's an entity. And as a legal person, it can sue and be sued. It can own property. It can even commit crimes for which the directors might have to go to prison. We in England use the initials LTD at the end of the company name. LTD stands for limited, meaning the liability, the risk that the directors or the shareholders might have to pay the company debts from their own money is limited. All they can lose in respect of paying the company debts is the money they paid to buy the shares. So they have limited liability. That's why we call it a limited company. Right. So their personal liability is limited. They can't lose their house or their car or the money in the bank. Now, sometimes because of this, people set up companies intending to use them to commit criminal acts. The verb we use to do something wrong is to perpetrate. We perpetrate a lie, perpetrate a crime, perpetrate a fraud. Fraud is a criminal act. Fraud is dishonestly misstating the facts with the intention that you will achieve a financial benefit from this, or that the other party will suffer a financial loss from this. It is a crime. It is not only what's called a misrepresentation, which will give somebody else the right to terminate the contract, but it's also a crime. So when a company is used to carry out, perpetrate a fraud, or acts beyond its powers, ultra vires, ultra, Latin of course, meaning beyond, and vires meaning power, beyond its powers. The company does something which is not authorized to do. Well, in that case, the court may disclose to the general public the names, addresses, and identities of all the shareholders if they've been involved in this crime. We call this lifting the corporate veil. You know that a veil is the piece of cloth you wear in front of your face when you get married. The corporate veil means the secrecy of the names and addresses of the shareholders. So the court lifts the corporate veil. It discloses to the general public who the shareholders are. And then it makes an order against these shareholders who've used the company to commit a crime to pay personally for the losses. It subjects them to personal liability. Right. Now, I'm not going to go through the whole thing in this detail, but I just want to deal with a few words. Legal entity, well, that just means a legal person, not a human being, but a thing, a company, a charity, a government. A properly registered business is an entity. Now, there's a huge difference between a company and a partnership. A partnership is merely an association of business people. The definition of partnership is two or more people acting together for a common purpose with a view to making a profit. So if I said to you, oh, let's all go to the cinema this evening, well, we've all got a common purpose in meeting outside the cinema, but we're not intending to go into business, so it's not a partnership, it's just a loose social arrangement. Now, a partnership is different from a company in that, first of all, you don't have to register any documents with any government anywhere to form a partnership. You don't have to have anything in writing. As you know, in the common law, you can enter into contracts without it being in writing. Merely acting as if you'd entered into the contract is usually sufficient. Agreeing with somebody else and then shaking hands, that could form a contract. There are some exceptions to this, but I won't deal with them this evening. So a partnership is an association of business owners, but they've not protected against the debts of the business. They have what is called joint and several liability. By that, I mean they're jointly liable for all the debts of the business. Let's say there are 6 partners, then all 6 partners are liable for the debts of the business. But let's say the business is in trouble. It has debts, and only 2 of the partners have got any money. Well, it doesn't make sense to sue the other 4 who don't have any money, because they can't pay even when you get a judgment against them. So we sever, S-E-V-E-R, to cut with one blow. We sever the 2 partners. Sever. We sever those 2 partners and we just sue them. We bring proceedings against them only. That's why we say that the liability is joint and several. Now, the other thing which we'll look at later in contract law is that all the partners are agents for each other. So one partner can bind all the other partners, even if they didn't give him authority to do whatever he's agreed to do. He can still bind them in a contract and lose the money. So it's very important you check on who you're going to go into partnership with. Right, so partnership is very different from a limited company. But the one thing about partnership is it has tax benefits. With a company, if a company makes a profit, when the company makes a profit, the government will tax it. And then when the company distributes some of the profit to its shareholders in dividends, payments, the company will tax, let's say that the government will tax the company when it pays a dividend. And then when the shareholders receive this dividend, this payment, they'll have to pay tax as well, because it's income, it's unearned income. It's usually charged at 10% more than the standard rate of tax, because it's unearned income. Partnership, on the other hand, only gets taxed once. The partnership makes a profit. That's fantastic. Doesn't pay any tax on it. When the partnership distributes the money to the partners, then the partners pay tax on the money they've received. So that's only one set of taxes. Now, if the partners are actually working in the business, it's earned income. So it's taxed at a lower rate of tax because they've earned it. If, on the other hand, they've just invested in the business and the others are doing the work while they sit back and take a percentage of the profit, then it's unearned income and they'll pay a higher tax. But you can see there are tax advantages to being in a partnership, but it's dangerous in terms of having to pay the debts of the business. Right. Now, in the West, everywhere outside Eastern Europe, basically, companies are formed by applying to the National Registry of Companies in whichever country you're in. And there will be 2 documents forming the constitution of the company. Provided the documents are in order, the National Registry in the UK, it's called the Companies Register, the Registry of Companies at Companies House in Cardiff, down in Wales. They will issue a certificate of incorporation. This document is evidence, proof that the company actually exists. Now, the 2 documents which the Companies House needs to see before which form the constitution of the company are the Memorandum of Association and the Articles of Association. The problem comes in that in America, they have the same 2 documents, but they've given them different names. They call them the Articles of Incorporation and the Articles. Yeah, the Memorandum of Association sets out the general principles of the company. What this company is going to build aeroplanes. That's our objective. It also states the number of shares which the company authorizes itself to sell in order to raise money to go into business. The company can only sell that number of shares, although it can, subject to including this power in these constitutional documents, it can authorize itself to increase the number of shares it can sell. It must also state the initial price at which these shares are going to be sold to the public. We call this price the nominal price because nobody really knows the value of the shares. The company hasn't started trading yet. The company authorizes itself to sell the shares to raise money. We call this process capitalization because the money raised is the capital. Now, let's say the company authorizes itself to sell 1 million shares and that the nominal price, also known as the par price, meaning parity, what is called the par value or nominal value is £1 each. So in theory then, the company could raise £1 million. It could sell 1 million shares at £1 each. That's the maximum, basically, it authorizes itself to raise. So we call this amount the authorized capital. Remember that? Number of shares and the price at which we're going to sell them is mentioned in the memorandum of association. And this £1 million is the nominal capital. Of course, the company may not manage to sell all of them. The ones it does sell, let's say it sells, it doesn't need £1 million on day number one. It needs £50,000 to sign the lease of an office, buy some computers and office furniture, pay some salaries for the first 2 or 3 months. So it just sells 50,000 of the shares. These will then be the issued share capital. We have issued the shares to people who've purchased them. So this is the issued share capital is 50,000. Right. Now, the internal rules of the company, how many directors are needed for a quorum, how much notice must be given to the shareholders of the annual general meeting, these are all contained in the Articles of Association. So we've got the Memorandum of Association setting out the objectives and the Articles of Association setting out the rules in which the companies run. Now, it's a lot to say Memorandum of Association and Articles of Association. So what we say is the Mem and Arts. Can I see the Mem and Arts, please? Now, the great problem between British lawyers and American lawyers is that the Americans call the Memorandum of Association the Articles of Association. So when a British lawyer wants to see the internal rules, he'll speak to the American lawyer, say, send me the articles. And the American lawyer thinks he wants to see the objectives and sends him the American equivalent of the memorandum. So be made very sure, if you are dealing with American lawyers, that you're both speaking about the same thing. Right, so the Articles of Association contains all the internal rules, including possibly the procedure to be followed to issue further shares, to raise extra money, to maybe take over another company. Now, every company must have an annual general meeting, known as an AGM, annual general meeting. There's one annual general meeting a year. The company may have 200 meetings, but only one of them is the annual general meeting, at which the shareholders will vote as to who they want to be directors for the next trading period. All the other meetings of the company including meetings of the shareholders, will be called extraordinary general meetings, EGMs. Yeah? All sorts of things can be discussed at the EGMs. You must, if you're calling an EGM, you must not only give notice, but if it's an extraordinary general meeting of the shareholders, you must also tell the shareholders what's going to be discussed. The shareholders may live in Tokyo or New York. They don't know whether it's worth their while getting on a plane to come to the meeting. So you must tell them what's going to be discussed. Right. Now, the board of directors runs the business on a day-to-day basis. The shareholders own it. But under the common law principles, the shareholders, once they've appointed the board of directors, must leave the board of directors alone to get on with running the business. In general, the shareholders can control, to some extent, the board of directors by refusing to vote for them at the next annual general meeting. But they can't turn up every Monday morning to say, what are you going to do this week? Let me see the books. Let me see the accounts. What decisions are you taking? You know, the common law principles are, once you've appointed the directors, they must be left alone to run the business as they see fit. Right. Now, what have we got here? In general, you will find on the board of directors, it's usual to nominate one director as the chief director, called the managing director, or the chief executive, or the chief executive officer, or the chief operating officer. Basically, the title doesn't mean anything. There's no legal inference from the title, but it's the principle that one person will control the meetings, make sure a record is kept of everything that is said and decided, although it's by tradition, the managing director at the meeting, or the chief executive officer, or the chief operating officer, by tradition, although they'll chair the meeting, they won't actually vote unless the other directors are evenly tied, 5 and 5, 5 for the proposal, which we call a motion, and 5 against it. At that point, the managing director, the chairman, the chairperson, the chairwoman, will make the final deciding vote. We say a manager, meaning the managing director, is delegated supervisory control, to delegate, to give somebody the power. Right. Now, in general, a company's employees only owe one duty to the company, when it's not, believe it or not, to do their work. Their duty that they owe is a duty of confidentiality, to keep the business of the company secret. Directors, on the other hand, owe many more duties, as do senior managers. They owe what are called fiduciary duties. Right. They also owe duties of care. Well, the duty of care, in a way, is close to fiduciary duty. Let me explain. The duty of care does not mean to be careful in your work. The duty of care means the duty to take care that you obtain all the necessary information to enable you as a director to make an informed decision at a company board meeting. If you don't bother to take the care to obtain the information and just vote yes or no without obtaining the information, you're in breach of your duty of care. And although normally you can't be sued for the debts of the company, if it can be shown that you're in breach of your duty of care as a director and your failure to obtain the information leads you to voting for something that causes the company a loss, you can be held directly responsible for that loss, and you can be ordered by the court to pay for that loss because you breached your duty of care. Now, what's a bit more difficult to understand is the fiduciary duty. A fiduciary duty means a duty of loyalty to the company, that is to put the company's interests above the interest of any other company, and also a duty to put the company's financial interests ahead of your own financial interests. So, if you hear of an opportunity to make a profit, and you know your company would be interested in it, you must tell the company. You can't take that opportunity to make a profit yourself. You'd be in breach of your fiduciary duty. And again, the company could sue you for breach of your duty. Well, fiduciary duty basically means it comes from the fact that you know everything about the company as a director. So you've got to act in the best interests of the company, not for your own interests or for the interests of a relative or a friend. Now, in general, you will find the courts don't like to get involved. It's called the business judgment rule. It's not in this text, but basically it's a defined area of the law that judges understand that whilst it may appear at first sight, at first appearance, that somebody has not acted in the best interests of the company, the judges know that they themselves are not directors. It may well be that the director, who appears to have sold something at a very low price, may be thinking in the long term. Perhaps they want to tie the other company in to their own company so that in 2 or 3 years they can make a huge profit from them. Judges understand that they don't really understand the running of the company as well as the directors do. And so unless it's really obvious that some sort of criminal behavior has taken place, or some very, very clear and obvious breach of the duty of care or breach of the duty of loyalty and the fiduciary duty, the courts will assume the directors were in fact acting in the best interests of the company under what is called the business judgment rule. Right. A conflict of interest is when your interests conflict with the interests of the company. For example, my company buys cocoa beans to make chocolate. Right. I go to Africa to buy cocoa beans, and I find an opportunity to buy a huge number of cocoa beans at a very cheap price. And I think if I purchase those cocoa beans myself, I could set up my own chocolate manufacturing company. So I do so. Well, that's a clear conflict of interest. And again, I can be sued by the company for my failure to be loyal to the company and my failure, my breach of the fiduciary duty. Now, although it's not mentioned in this text, I'll deal with one other thing. Shareholders get to appoint directors, but they have other powers. Shareholders basically own the company. If there are 1 million shares and I own 1 share, then I own 1/1,000,000th of the company. Because I'm the owner of the company, I have a power which derives from the fact that I'm an owner of the company. And provided a minimum number, usually a percentage of about 10 or 12% of the shareholders agree, they can sue the directors on behalf of the company when the directors fail to do something that they should do. Perhaps the directors are acting in a way which causes the company a loss. Perhaps they're failing to take advantage of an opportunity to make a profit when they should do so. The shareholders can sue the company under what is called a derivative court action. There's a lot of law on this, and I'm not going to deal with it in this course because we're looking at derivative, because we're looking at vocabulary and legal writing. Derivative court action means the ability of the shareholders to sue the directors on behalf of the company, where the directors have failed in their duties, whether their duty of care or the fiduciary duty or in some way, they're just failing to take advantage of an opportunity when they should take advantage of it. Right. Now, lastly, at the annual general meeting, there will be various reports presented to the shareholders, and all the directors, or usually, A large number of the directors, if not all the directors, will resign immediately before the meeting and will then put themselves forward for election to be directors for the next trading period. Right, so that's what the annual general meeting is about. We're voting for the directors for the next trading period. However, at the meeting, the company finances must be shown to the shareholders. A report must be drawn up by a company of auditors, PricewaterhouseCoopers, Deloitte, Ernst & Young, etc. They must draw up a report for the shareholders. The company will pay the auditors to do this, but the duty of care to make sure all the information in the report is accurate is owed to the shareholders. Now, the report includes two very important financial documents. The first is the balance sheet. The balance sheet is a document which shows all the assets of the company and all the things that the company owes, its liabilities, on one particular day, usually no more than about 6 or 7 weeks before the annual general meeting date. We call it the balance sheet because of the way in which the accounts are drawn up. It's a long list of figures, long list of numbers. And the bottom line would say the assets on the left-hand side and the liabilities on the right-hand side. The two amounts, the two numbers at the bottom of those two lists should be exactly the same. In other words, the two lists balance. I haven't got time to go into the accounting principles of this, but it's basically a bookkeeping exercise. That's the balance sheet. It shows, it's a snapshot showing what the company owned and what the company owed on a particular date, usually no more than 6 weeks before the annual general meeting. Now, the other document, the other financial document which must be shown is what is called the profit and loss account. This is a list of all the money coming in and all the money going out for the last trading period, for the whole last 12 months. Every single penny, dollar, kopeck, every single penny must be shown that went in and went out. Now, hopefully, it'll show there's a big profit, which then gets transferred to the balance sheet, which is why the balance sheet figures balance. Now, we talk about companies being healthy. This has nothing to do with the working environment. Healthy means making big profits. If the company's healthy, it means it's got lots of cash, lots of money. Is the company healthy? Yes, very healthy, meaning we've got lots of money coming in. So healthy profits will lead to what is called a bonus issue or a capitalization issue. Right, now, the company makes profit. It will need some of that profit. It'll need to put some of it aside for the next trading period. But that will still leave some money left over. So it can give this money, it can return this money to the shareholders. It does this through making a payment called a dividend. Now, that would be what is called a capitalization issue. We're going to issue a dividend. We're going to send back money, capitalization issue. However, sometimes companies don't make a profit. They can't issue a dividend. So the shareholders are not happy. They think about selling their shares. Oh, let me just look at this. Let me just, let me just write this, okay. So you want me to write something in the chat box, okay? So well, you can see on the screen, okay, bonus issue here. Let me get rid of this. And you can see here the words capitalization. Right. Capitalization means sending some money back to the shareholders in a dividend. Sometimes companies don't make enough money to pay some of the money back to the shareholders. So to stop the shareholders selling their shares and leaving the company, which will, of course, drive the price of the shares down, they issue extra shares. For example, for every 10 shares, we can't send you money this year, but for every 10 shares in our company you already own, we'll give you a bonus of an extra share. It's called a bonus issue. Next year, when we do make a profit, you'll get extra dividends because of this bonus. And also, even now, even though not giving you money, you could take this bonus share and you could sell it to other members of the public and get some money that way. Yeah. Right. Now, on the other hand, if the company is not doing very well, it's unhealthy, then it may not be able to pay its debts. The word insolvency is the legal position whereby you are unable to pay your debts as they fall due for payment. You are insolvent. You're not bankrupt yet. You may have $20 million in land, but you haven't got $50,000 in the bank to pay your employees. So technically, you're insolvent. It's not good to be insolvent. And if the insolvency continues, then eventually somebody will apply to the court to have you made bankrupt. A human being or a company can be made bankrupt. That is, all their assets can be taken, sold or turned in, sold to raise cash, and the cash given to the creditors, the people to whom the company owes money. That's bankruptcy. And we call this process liquidation. We turn the assets into liquid cash. Now, in the law, in business English, you'll find a lot of idioms about business which relate to water, liquid cash, insolvency, like dissolving in water. We say, can you float a loan? In other words, means, can you give me a loan? Can you float a loan for the company? Will the company pay its debts or will it go under, meaning go under the water? There are sort of four areas of life from which our business idioms in English are drawn. It tells you a great deal about England 300 years ago. First, warfare. Second, gambling. Third, farming. And fourth, water. I think it has to do with the fact that we're an island race. To do business, we have to get on a ship somewhere and sail somewhere to go and do business. That's why I think water and money in business is so closely related in relation to idioms. And in farming, we talk about opening new branches. We're going to reap the benefits of our investment. We're going to branch out. And in warfare, well, we're going to hit our targets. We're going to take over new territories. And in gambling, we say things like, there's a lot at stake here. The gambling stake. Right, now then, what's that? Okay, now then, let's have a little exercise, because it's not interesting really for you to listen to me lecture. I'd much rather deal with exercises. I've taken a bit too long to go through that text, and I apologize. Now, what we got here, let me just reduce this size slightly. What we've got here is a list of 10 roles in a company: auditors, company secretaries, directors, liquidators. And what we've got here are 10 definitions, A to J, but the definitions are mixed up. What I want you, I don't know, let me just say this, I do not want you to speak, okay, not this time. I want you to write the number of the answer in the chat box for me. Right, so let's have a look here. Look at G. Who or what is G? Which number? 1, 2, 3, 4, 5, 6, 7, 8, 9, or 10? Who or what is G? A member of a company by virtue of an acquisition of shares in the company. In other words, buying or somehow obtaining a share in the company. Right, now look, it's boring if you don't join in. So don't be worried about making mistakes. There are no mistakes at this point in the course. Okay, so who or what is a member of the company by virtue or because they own a share in the company? Who would that be? That's 13 of you. Now I've got 48 of you in the group. Okay, so 15 of you. Now, take a guess. It's boring if you don't. As we often say, what's the worst that could happen? Okay, I'll get it to 20, then we'll look at one more, please. One more answer from somebody. Just write the number in the chat box for me. No? Okay. Good, everybody. Yes, it's a shareholder. You become a shareholder through owning a share in the company. You hold a shareholder. Right. Now, let's have a look here. Who do you think this is? The person appointed by a court or the company or its creditors to wind up the company's affairs. To wind up means to close down the company. I know wind up, we wind up clocks, we wind up toys to make them go. But in company language, winding up means closing the company down. So who will that be? It's appointed by the court. Appointed by the court or the company or its creditors as a result of a court order, usually, to close the company up, sell its assets and turn them into liquid cash to distribute to the creditors. And so we got here. 4, yes, well, yes and no. Yes, okay, we'll go with that, liquidator. Because also it might be the official receiver. Appointed by the court, but liquidator will do for the time being. The person to take over the company and close it up. Right. Okay, 4. Who said that? Alina, very good. Okay. Who said? Okay. Right, now, I want to deal with this word because we didn't deal with it in the text. Proxy. Right, this is big part of company law. Let's imagine we got shareholders all over the world. Now we're going to have the annual general meeting in London. Some of the shareholders are in New York, some are in Tokyo, some are in Buenos Aires. They don't want to get on a plane to vote in person, so they send somebody to vote in their place. This person is called a proxy. Now, sometimes they don't send a person. Sometimes the company says, these are the proposals. Do you want to vote yes or no? If you want to vote, write on this form and send it back to us. It's a proxy voting form. So proxy can be referred to the vote in which written votes are going to be counted, or a proxy can refer to the voting paper, or a proxy can refer to the person you send on your behalf to vote as you instruct them, as your agent. A proxy. So a proxy is, let's have a look here. All right, so a proxy is A. Very good, everybody. Okay. Who or what is this? D, the person engaged in developing or taking the initiative to form a company, arranging the capital, in other words, raising the money, obtaining the personnel, etc., making arrangements for filing the documentation. Who or what would that be? Again, it's not a word we saw in the text. Who would that be? You have the same sort of person in Ukraine. What do we call them? Now we're going to overrun by 10 minutes this evening, and I apologize because I've gone too slowly. Another exercise before we finish. I want to move on to something else to do with vocabulary. Let's have a look. So a proxy would be, so the person engaged in developing it would be 5. Oh, no. It wouldn't be 5, a big one. It would be 7, the promoter. The promoter develops, takes the initiative to form the company, promotes the company, forms the idea, gets the company registered. That is a promoter. All right, I'm going to send you this exercise, I think, as a home task as well. Right, now then, I want to go on to something else, okay? Right, now what we're going to do with some vocabulary. At the end of each of these exercises, end of each module, I should say, at the end of each module are some exercises on vocabulary. Now, one of these is called the odd one out exercise. What we got here is groups of 4 words. Oh, for some reason it went to, okay, 4 words. 3 of the words mean something similar. They're close to being synonyms, but the other one doesn't fit. For example, we can stipulate something in the company articles. We can specify something. We can prescribe something. In other words, what we're doing is we're instructing. Whereas to proscribe with an O means to prohibit. So stipulate, specify, prescribe, they all mean something similar. Proscribe means something totally different. It doesn't fit. It's the odd one out. It means to prohibit. Notice the difference between proscribe and prescribe. Notice also the tiny change in pronunciation. Proscribe, proscribe means don't do it. Prescribe means you must do it. The doctor will give you a prescription. He prescribes medicine, which you must take. Proscribe, well, that means it's prohibited. It's against. In Rome, there were proscription lists of citizens to be arrested and executed by the emperor. Prescribe means prohibited. Right, so let's have a look at number 2. You've got to write in the chat box for me the odd one out. We've got succeeding, elapsing, ensuing, subsequent. Which word doesn't mean the same as the other 3? Succeeding, elapsing, ensue, ensuing, subsequent. Good.
Subsequent.
Okay. Now again, don't worry about making a mistake, okay? But I do want, that's it. Take a guess. You got a 25% chance of being right just from making a guess. Wayne Gretzky, the ice hockey player, said he missed every shot which he did not take. In other words, if you don't try, you're bound to fail. Okay? All of you have had the sufficient courage to come to England, start again. So I'm sure you're all been prepared to try. Give me an answer. Out of the 49 of you in the lesson, there are 16 answers. Come on. All right, let's see what we got. Okay. Elapsing. Right, succeeding means the next one. Ensuing means the next one. Subsequent means the next one. Elapsing means it's stopped because time has passed. The lease has elapsed. Your time with us has elapsed. And this lesson is about to elapse. Right, here's an easier one, number 3. Responsibility, duty, discretion, obligation. Now we're talking about directors, right? They've got responsibilities, duties, discretion, and obligation. Which is the odd one out? Subtle difference between one of them and the other 3. Good. Discretion, absolutely. Discretion means choice. Be discreet means choose very carefully who you tell things to. Discretion means choice. Very good, everybody. Mila, Elena, Valeria, Alexei, Stanislav, very good. So it's discretion. That means a choice. Right, next. Okay, some of these words, as we go through the course, these words will become more and more advanced. Right? Prior, previous, prerequisite, preceding. So we've got prior, previous, prerequisite, preceding. Okay, so which is the odd one out? Very interesting, very subtle difference, very difficult, very difficult. Okay, that's what we got. Oh, I've got a good choice here, preceding, prior, prerequisite. Right, prior means before. Prerequisite means something must happen before something else happens in the contract. For example, you employ me to build a house for you. We sign the contract, but the contract says I only have to start building once you have obtained the planning permission. So it's a prerequisite that you obtain the planning permission before I start building. So prerequisite and prior to me building means before I build, you have to obtain the planning permission. Preceding means in front of. So in other words, in front of, like prerequisite or prior, it's before. Whereas previous means last, the last lesson, the previous lesson. There's a subtle difference between the two, okay? So in fact, it's previous. Prerequisite, something must happen before something else happens. Preceding means in front of, prior means in front of. Previous, well, actually I say this, you know, I've told you that, maybe I'm wrong, maybe it is prerequisite. Previous, I suppose, means before. Prior means before, preceding means before. Sorry, I'm wrong, everybody. Prerequisite, quite right, prerequisite. Something which must happen before something else happens. Sorry, it's a requirement. You're quite right, everybody. It's prerequisite. Everybody, I apologize. Okay. Now, the next one is very difficult because it's got idiomatic language, but we use it in the law. Margin, leeway, latitude, interpretation. Wow. All right, can anybody, we'll do this very quickly. Anybody see which the odd one out is? Because I don't think you know what some of these words mean. Let me explain what leeway is. Leeway is the amount of room which a ship has to leave the harbor. The leeway, the amount of room on the left and the right for the ship to leave the harbor. Latitude is the lines, parallel lines around the Earth, the lines of latitude. Tropic of Cancer, Tropic of Capricorn, the equator, they're all lines of latitude. Margin, this is the area at the side of the page. That's the margin. Now, all of them refer to the amount of room. Oh, very good, everybody. Valeria, Anastasia, Anna, Vika, excellent. It's interpretation. All these three relate to the amount of room you have, the amount of room to interpret something, to understand something, the margin for error, the leeway for movement, the latitude, the amount of movement you have in relation to understanding what a contract means. Whereas interpreting means understanding what the contract means, interpretation. These first three refer to the amount of room you have, the amount of movement. Interpretation means your understanding of the contract. Very good, everybody. I didn't think you'd get that. All right, last one then. Preclude, permit, forestall, prevent. Preclude, permit, forestall, prevent. Very good, everyone. Anna, Vika, Yulia, Elena, Yulia. Wow, Lyubov, yeah, great. Christina, Olga, yeah, permit. Christina, great. Valeria, excellent, yeah, permit. Preclude means prevent. Forestall means to stop somebody doing something before they do it. Let me forestall you from speaking by telling you I won't listen. Let me prevent you from speaking by telling you I won't listen. Let me preclude means prohibit you from speaking, whereas permit means to allow. Okay, very good. Permit, great, yeah, good. All right, everybody. Well, unfortunately, we come to the end of this evening's session. I'm going to set you a home task, and it's going to be some of these vocabulary exercises, okay? And we'll also, in the next lesson, look at the use of the words shall and may in relation to legal English and their use in documents. All right, have you got anybody got any questions on anything we've looked at this evening? Let me stop sharing. Let me bring myself back on screen. Okay, anybody got any questions on anything you'd like to clarify? Any words or phrases you've come across this week that you'd like to ask about? Any legal points?
Where
No?
where we can show this book? What you
let me
teach
see.
us?
Who's that? Oh, it's Alexander. Yeah, Alex.
Yes.
I'm going to show. Sorry, I haven't sent you the link. I'm going to send you the link so you can download the book yourself. Just a minute, Alexander.
Okay, thank you very much.
But I have about 150 emails a day coming in. It'd be very helpful if you sent me an email tomorrow morning just to remind me, Alexander, okay? Otherwise,
Okay,
it might, even though I've written it down, it might go out of my head, okay?
Yes, thank you.
Okay, all right, and again, let me remind you, those of you who want to get involved in the conversation groups, please write to me. I've got some of you already, about a dozen, 15 of you already said yes. Those of you who want to get involved and will be the coordinator of your group of 6 or 8 people, please write to me as well so I know who to put in charge of getting the group together, and I'll show you how to set up a Zoom conference call each week. Well, Victoria, that's very kind of you to say.
Sorry, Richard.
Yes,
I sent message, but you didn't reply for me.
No, I didn't. I wanted to wait. Yeah, I wanted to wait until this lesson until I got all the replies in, but I will reply to everybody that writes to me in the next 2 days. Okay.
Mm-hmm. Thank you so much.
No, thank you, everybody. I hope everything well. Maybe at a point, one of us to form the group to share the book. That would be a great idea, Victoria. Let me put you on the spot now. Would you be prepared to do that, Victoria? Thank you very much. I'll write to you tomorrow, Victoria. Thank you very much. Okay, thank you, everybody. Have a lovely week. Great, I got it. Yeah, okay. Have a lovely week. I'll see you next week. In November, we'll probably start to move to 2 lessons a week, if you can do that. I want to speed up your ability. I hope to see you all again before too long. I hope to visit the UK later this year. I've got to go to Macedonia in a few weeks, and I've got to go to Turkey, and I may have to go to Dubai as well. But I am hoping to get to the UK before Christmas. So hope to see you soon. Okay. Bye-bye, everybody. See you next week.
Bye-bye.
See you. Bye.
Nice holiday.
You're welcome. Bye-bye, everyone. Bye-bye.
Thank you so much. Bye.
Bye.
Oh, bye.
Thank you.
Bye-bye.
Many thanks.
Thank you, Irina. Thank you. Thank you for joining, Anastasia. I'm sorry I cut you off. You're about to tell me which city you're based in. Which, yeah, I'm talking to you on the iPhone, Anastasia, this time. Well, where are you based, Anastasia?
Hello, I'm live in Erith. It's near with Cambridge.
Oh, yes, of course. Yes, of course. Yes. I was in Cambridge about 2 or 3 weeks ago, briefly.
And now I'm working in Cambridge.
Are you? Oh, that's great. What are you doing? Are you
I'm
working?
in medical practice.
Good. You're a receptionist.
Yeah, I'm receptionist.
Oh, well. Okay. All right. Well, look, lovely to see you. And I'll see you next week.
Nice to
Okay.
meet you. And
Okay.
next lesson at Tuesday or Wednesday?
It'll be Wednesday. Is that okay? Wednesday?
Yes, of course I can in Wednesday.
All right. Okay. See you then. Okay.
Thank
Bye-bye,
you so
everyone.
much. See you later. Bye-bye.
Bye-bye.